Society event, our employment law panel. I'm Claudia and I'm the non-law representative for one of them. And co-hosting with me today is Mikal, who's our events officer. Just as a matter of housekeeping before we begin, I would ask if you could all please mute yourselves unless you're talking. And the session is going to be recorded as well. So if you have any questions, just put them in the chat box too. And we'll try to answer them at the end if we've got any time or if they're answered during the session. So to introduce our panelists, we've got Rebecca Tuck, QC from Old Square Chambers, Amy Rumble from Park Lane Plowden, Sarah Clark from Three Paper Buildings, John Horan and Rachel Barrett from Cloisters Chambers, and Emmeline Plews from Blackstone Chambers. So if we are ready, would the panelists like to start by introducing themselves and just giving an introduction?
Hi, shall I go first, as you mentioned me first?
Sure.
So I am Rebecca Tuck from Old Square Chambers. I became a QC last year, just before the world locked down. So haven't had the chance to have a party, which is the major reason for becoming a QC, as I'm told. I went to a state school in Stoke-on-Trent and then went up to Oxford. I was the first and only person in the history of my school to do that. The school was then put into special measures and demolished. So I am the one and only. And I had heard of Oxford and Cambridge, and they always said Oxford first. And I'd heard of Staff's Uni in Kiel, and I definitely wasn't staying in Stoke. So I decided I would go to Oxford. And I was incredibly naive as to how competitive it was. And that naivety continued really when I decided I would go to the bar and I would do employment law, and we'll come on to those issues. So I went straight through. I did a law degree. And in fact, my parents wouldn't have allowed me to go to university to do a vocational, to do a non-vocational subject. As it happens, I was told I wasn't allowed to do A-levels if I was going to go and get a job for which I didn't need them. So I had to have a career in mind, and I went straight through from university, bar school, pupillage, and I was a tenant in Chambers by the time I was 21 and a half. And I've been there ever since. I've had 2 lots of maternity leave, so I've got 2 children. The joys of the bar, I call it maternity leave in a very grand sense. It means that I had a period of away from work when I earned no money, and came back and carried on. But the constant throughout is that the bar is a challenging career, and I have a love-hate relationship very often with that. But employment law I have much more of a love-love relationship with, because it's endlessly fascinating. So that's me.
Thank you very much. So Amy, if you would like to be the next person.
Yes, hello, good evening everyone. My name's Amy Rumble and I'm a junior tenant at Park Lane Plowden Chambers. We're based on the Northeastern Circuit, so I'm on circuit London. However, I graduated from Queen Mary University in 2016. I did my law degree down in London at Queen Mary. I then did pupillage in 2017 to 2018 with Chambers, based back up in Newcastle. I should say I'm originally from Leeds, and went down to London to study at Queen Mary, then looked to go back up north, and my chambers is currently based in Leeds and Newcastle, but my pupillage position was in Newcastle, and that was because my proposed supervisor, who had a sole employment practice and is now a tribunal judge, he was based in Newcastle, so I undertook pupillage there, and I'm currently now still based in Newcastle, having completed my pupillage and becoming a tenant in October 2018, and then falling in love with the city and staying up in Newcastle since. I'd say I did pre-pandemic travel quite a lot for my employment work around the north, and but now not so much, more so on CVP, but I'm sure we'll come to discuss that soon. And but my practice comprises probably 75% employment law and about 25% personal injury work. So I still have that slight divide, not yet sole an employment practitioner, but I do have a very strong passion for the employment work I do. So that's a bit about me, preamble about me, but I look forward to talking to you all shortly.
Thank you very much.
Thank you.
Sarah, if you'd like to be the next person, I would be grateful.
Good evening, everyone. My name is Sarah Clark. I am an employment barrister based at 3PB. I'm at a very large common law set, and we specialise in many different areas of law, but we also have specialist teams. We've got 6 bases over the country, from Birmingham down to Bournemouth. I'm based in Bristol. As I say, I've been a barrister since 2005. As you might be able to tell from the accent, I am not originally from this part of the world. I went to school in Belfast. I went to a state school myself as well, and then was lucky enough to be able to go to Oxford. And my school was very good at effectively pushing people if they thought they had the aptitude, which has been really helpful for me. I also do a little bit of commercial work where there's an overlap with employment matters, such as bonus payments, restrictive covenants, that type of thing. And like I imagine everyone else here on the panel, I do a lot of traveling for my job, so I have become very familiar with various travel lodges and whatnot over the country.
Thank you very much, Sarah. Emmeline?
Hi there. So yeah, I'm a very new, very young junior barrister at Blackstone Chambers, and a bit like Rebecca, I have not yet been able to have the party we were promised because of being locked down at the point when I was taken on. So to the extent that I can assist, I hope what I can talk to is life at the really, really junior end of the employment bar. In terms of me and my route here, so I graduated having done a non-law degree about 10 years ago, and took quite a winding route to the bar because I went and became a social worker before coming back and doing the law and then doing the BPTC. So I've had a bit of a winding route before winding up here. But I've always known that when I did get here, I really wanted to do employment work.
Thank you very much. Rachel?
Sorry, lost the mute button for a moment. Hi everyone, my name's Rachel Barrett. I'm a barrister at Cloisters Chambers, along with my colleague John, who's also on the panel. In terms of my background and how I came to the bar, I went to a state school in a village in Cambridgeshire. I did a history degree at SOAS, and like Emmeline, I then took a rather winding route to the bar, and I lived abroad and I worked in mental health in London for a while. And then in my late 20s, I decided that I would quite like to be a lawyer. Actually, I thought about becoming a social worker, Emmeline, and I did a pro-con list. And on my cons for lawyer, I didn't know any lawyers at this point, and one of my cons was would have to hang out with lawyers, which actually I would say is now a pro, but at the time I was deeply suspicious. I did the graduate diploma in law part-time because I was still working full-time. So it took me a while to get to the bar. And then I did pupillage at Cloisters, which is a set that has a large employment group, and kind of gravitated towards employment law. So I did my pupillage 2012 to 2013. I then spent a year in the Supreme Court as a judicial assistant, which was a fascinating year. Came back to Cloisters and have been practicing there ever since. And I was appointed a part-time employment judge last year, so I'm currently on a big learning curve in a part-time judicial position. Yeah, so that's a potted history of me, and I look forward to answering your questions this evening.
Thank you, Rachel. And John?
Well, I'm a rump kettle of fish. I did the classic old style approach to the bar. I was at Westminster School. I was at Trinity College, Cambridge. I was then at the bar school, and then practiced for about 7 years, and thought I knew absolutely what the bar was about and what my life was about, and that I was cleverer than everyone. Then on the day before the millennium, I suffered a severe stroke and was not at the bar for about 16 months. I then came back to the bar, by which time I was a month into being a tenant of Cloisters. And it opened my eyes. It opened my eyes to the justice that all sorts of people, and I had been a discrimination lawyer, acting for both sides, and all of a sudden it wasn't a nice point at all. I could see the injustice. So I practiced largely pro bono. I ditched my respondent practice. I represented in employment tribunals and county courts, and only for claimants. I think I didn't believe that I could make it, but I did make it back, although many adventures in the way, some of which I got, for example, I had to take the bar standards board to court, and I eventually settled it, but only after the Bar Council acknowledged that they discriminated against me. I'm now a happy tenant of Cloisters Chambers with a thriving practice and do all sorts of new law, and I couldn't be happier. So that's me.
Thank you very much, John. First of all, it is our pleasure to host our guests tonight. And I think that we can begin with our questions, and we should follow the same order that the introductions went. So the first question is, what has attracted you to practice employment law in the very beginning? So Rebecca, if we can start with you.
I wish I had something more profound to offer, and I should, given that my dad was a miner who was on strike in 1984-85, and I ended up at the chambers that did a lot of the work for the NUM and representing Arthur Scargill at that time. I know this will be ancient history before most of you were born. I'm so glad that John's on the call to get my cultural references. So it should be something really profound, but actually I was quite active in the Oxford University Labour Club, and one of the guys in the year above me said, "Oh, all left-wing students do labour law." And do they? Oh, okay. So I signed up for it because we only had 2 options in my day at Oxford. By the time you did all the compulsory subjects that you needed, if you wanted to qualify as either a solicitor or a barrister, you only actually had 2 options. And so on that very thin evidence, I took labour law and absolutely loved it. I loved the fact that you got to see into all these different workplaces and the different lives that people were leading because it's such a profoundly important aspect of somebody's life, what they do day to day for the job. I mean, it's no coincidence why when you meet people at parties, if you remember back in the day when you actually saw people, one of the first questions they ask is, what do you do? So yeah, I fell into it, but then immediately loved it.
Thank you for your insight. Amy?
Yes, I mean, I have to agree. I don't have much of anything profound to say as to why I was attracted to employment law. I also somewhat fell into it. When I was in my final year at Queen Mary, I did some assistance at a legal advice centre in Waterloo, and a citizens advice bureau, and a lot of the stuff we were getting was employment tribunal claims and seeking advice on those claims. So I became immediately interested in that area of work, and became familiar with the basic type of tribunal claims and principles. And I also then went on to become interested in doing through work for the free representation unit. But again, I'd have to honestly say that my attraction to that was to get the advocacy experience, because it's one of the sort of only institutions that undergraduates or law students or BPTC students can join and actually get real life court advocacy experience. And so for me, that was the honest interest in it. But it was only then when I started doing that work and seeing that work in practice that I became really interested in it, and started to look at pupilages and sets that did that type of work, because I'd got that insight and experience. But again, I applied to mix civil sets, so sets that did other work as well. And then again, the final falling into employment law was when I actually started pupillage and was paired with a supervisor who had a sole employment practice. And therefore, my first 6 months was seeing employment tribunal work day in, day out, and somewhat fortunate that I loved it at that stage and have continued wanting to do it. But again, it would be falling into it somewhat, rather than going out and having anything profound to say as to why I actually sought to work in employment law. But I would completely echo what Rebecca said with regards to what I love about it now is being able to dip into all the different worlds and different workplaces there are. You know, it's every case is completely different in that regard, and you get insights into all these different types of jobs and workplaces and workplace politics. So I find that fascinating.
Thank you, Amy. Sarah?
Well, I actually started out thinking I wanted to do criminal and family law. And basically during my pupillage, I sort of tried various different areas of law. So criminal, family, property, personal injury, employment. And I very quickly realized that what I thought I wanted to do was definitely not what I wanted to do. And what you study and learn at university is very different from the practical reality of what you're actually doing. And yeah, I very much did not get on with the way it works at the criminal and family bar. And what I really enjoyed about employment was that it had a really nice balance for me of quite a lot of meaty, complex legal areas to deal with, but at the same time, a lot of interaction with people and clients, and a lot of advocacy and getting to go and actually argue the points in a way that some meaty legal areas of law, you might be sitting poring over documents for months on end without ever really getting anywhere near a client or getting into court. Whereas employment, I find, is a real nice mixture of both of those things. So that's what appealed to me, basically. It was just doing the job and getting on board with it. And then, yeah, over time, everything else really been dropped. So, yeah.
Thank you for sharing your insight. Emmeline, if you could please follow.
Sure. So I think my desire sort of from the very beginning to get involved in employment law was very much born out of having not maybe studied law as an undergrad degree. I think that when I first came to then learning the law in order to kind of go to the bar, I found a lot of it was quite dry. And I was just desperate for something which had human interest and human meaning. And the thing about employment work is that work really matters, and the world of work really matters to people on an individual basis. And so I was immediately attracted to it for that very reason. There was human interest there that was lacking, shall we say, in land law or or equity, for instance, to me. So I really enjoyed that from the beginning. And then as I got a bit more experience, I similarly got involved with the free representation unit and got the chance to do the advocacy. And so it was kind of a combination of factors which really drew me in, and I've sort of not really ever looked back or fallen out of love with it so far.
Thank you, Emmeline. Rachel?
It was by accident. I was completely clueless. I applied for pupillage whilst I was doing my GDL part-time. And this was the point when I still didn't know any lawyers or know what I was doing. The GDL doesn't have an employment law module. Like Rebecca, when she was choosing her electives at university, I had gone onto the websites of chambers and picked ones that seemed vaguely lefty and that they were trying to do good things in the world with a social conscience, sent a very mixed bag of applications out to all sorts of different areas of law. When I went for my pupillage interviews, the Cloisters interview panels seemed like the friendliest and most down-to-earth people I'd met, whereas some of the chambers seemed completely intimidating. And so I was very pleased to be offered pupillage there, and it turned out they did employment law, so that's what I ended up doing. But it turns out I love it, so it was a happy accident, but I'm sure you will all be much more savvy in making life choices than I was, so that's no example at all.
Thank you, Rachel. And John?
Well, again, it's really two periods of my life. When I first started out with law, I always said, oh, I'm soft commercial. I don't know. I don't even know now what that means. I loved employment law. In particular, I loved the fact that it was, yes, statute law, but also European law and various guidance and the interaction between all three things. And then I agree with the other panelists. I mean, the actual people that mattered were there. But then when I went back to the bar, I realized that I wasn't bullish enough, because a lot about the law, it seemed to me, it needed to change. And for example, the whole thing about reasonable adjustments to the court process, which is now enshrined in Harvey, and just as of January this year, is actually now one of the overriding principles: vulnerable people and disabled people. And that's fresh off the back. And I had a part in making that happen. And I didn't earn much money. I still don't earn much money. But I've suddenly discovered morality. I've suddenly discovered that I, as an individual, made a difference. And that was so important to me.
Thank you very much, John. The next two questions, I would like to ask them as one, because it was already touched upon by one of the panelists that employment law is a very diverse area. So I would like to ask, what does employment law entail? And what are challenges that employment lawyers face on a daily basis due to this very fact? So Rebecca, if you'd like to begin once again, I would be very grateful.
One of the reasons why you've got the panelists here all saying that we love this area of law is because of the sheer diversity, not only of the topics of law, whether we're dealing with transfer of undertakings or discrimination or unfair dismissal, but the type of people who we come across as well. So what does employment law entail? When I'm asked this question, it always takes me back to a typical working day I had. It must have been about 8 or 10 years ago, where in the morning I had a conference with 3 gorgeous wannabe actresses who were bringing a claim, wanting to claim national minimum wage because it was a profit share production that and the union, trade union Equity, were running a campaign to try and get these actresses to get the minimum wage, and it applied across the entire sector. A lot of young actors and actresses are being exploited by producers by the way that they set up. So I had a conference in the morning with the actresses who were talking about the difficulties of having any parts that involve them keeping all their clothes on at all times, which was quite a depressing aside. And then in the afternoon, I had a conference with a banker who had been burnt out and was bringing claims for disability discrimination, constructive dismissal, bonuses, and she was on a very large 6-figure sum every year and had been for very many years, and you know, her shoes were out of this world. Those who know me know that I'm very keen on shoes. So it's just completely diverse, and even if you're dealing with similar issues of law, it can be in a completely different context. So that's what does employment law entail? Whatever workplace situation can come up, you can come across. What are the challenges that we face? Various of the other speakers have mentioned the free representation unit, and for any of you interested in getting some advocacy experience and finding out more about employment law, definitely go for it and find out more about FRU and start volunteering for them. I remember the first case I was about to do in tribunal, which I had prepared to within an inch of its life, and the caseworker who was employed at the time just kind of in passing said, "Oh, you've read the latest Court of Appeal decision on GP that came out yesterday." What? And I honestly thought he was joking, and he wasn't. It's a very fast-moving area of law. So one of the challenges that it faces is one of the things that also makes it quite satisfying, but you absolutely have to keep on top of the case law and the changes that are coming through all the time. It's very dynamic. Over to the next speaker.
Yes, well, one of my first points was going to be that it's a constantly changing legal arena. And I was also going to echo, I think, what Sarah had briefly mentioned earlier, which was the overlap and balance between being a personable legal area. So you're dealing with issues from people, directly dealing and you know, it requires sometimes certain degree of empathy, understanding, dealing with vulnerable witnesses and the like, but also you've then got this vast legal area of complex laws to follow and apply that to. And so it's not sort of the black letter law type stuff you see in commercial and contract law. So it's just so multifaceted. There's so much to it that you can be doing. And I would say in terms of all of that, taking into account all the situations you might come across or deal with, all the ever-changing and complex laws, is that a challenge we face is that you have a lot of reading. So whether that's reading papers, reading the bundle, reading legal articles, reading. So if you don't like trying to digest large volumes of papers, then it might not be the area for you. And I say that when I refer in contrast to my personal injury practice, which is just nowhere near the amount of reading that employment law entails. But that said, it's interesting reading. But yeah, that's one point I would make.
Thank you, Amy. Sarah?
Thank you. Yeah, just echoing what's been said, I think each individual area of employment law could be a degree in itself. Discrimination and whistleblowing and TUPE, they're all massive. So I don't think anyone could ever say they truly knew everything about employment law. And I suspect every single case I do, I come across new cases. Yeah, you have to keep on top of it. And that's challenging in itself. But what can make it even more challenging sometimes is that the employment tribunal is often, claims are often brought by litigants in person. It's meant to be designed so that you can bring your own claim. You haven't got to pay a lawyer. And it's obviously a really good intention, because you want people to have access to bring their claims. However, in a very complicated area, it's not that easy. So if you've got a very complicated legal case, if you've got a litigant in person on the other side, it obviously makes your job very difficult, because there's obviously a fine balance between putting forward the best case for your client, but making sure you're putting to the judge all of the relevant law. So yeah, challenging law with litigants in person is definitely one aspect of the job, which is pretty difficult.
Thank you, Sarah. And to Emmeline?
I agree with everything that everyone said really already. I suppose what I'd perhaps zone in on a little bit more is a sort of from an academic perspective as well, just the diversity of approaches, because as people have already said, you've got your statute, then you've got the common law, then you've got EU law, and now of course retained EU law. You've got so many different canons of kind of ways of working almost, that you as a kind of, when you're approaching something in the preparation of it, you're really balancing lots of different ways. It's not just like being a kind of pure commercial lawyer where you have your approach and you can kind of, you've got to sort of combine all these ways of working and always modify the ways in which you're working to the context in which these situations arise, because what may work on a pure contractual interpretation in the workplace, there are going to be lots of different considerations to arise. And I mean, that's what I find fascinating about it, the way you've got the kind of black letter contract law, but it kind of gets softened in the situations that we're looking at, in the situations of work. And then I would absolutely echo the challenges of then in practice. You've got to, however complicated all that is and however much you've fretted in your own brain, you have to make it all comprehensible for your client, because they need an explanation. And you know, the kind of people skills that you need to do that are kind of endlessly fascinating in and of themselves, because you've got to keep all of that in your head and be able to explain it all comprehensively and in an articulate way, but at the same time you need to have also laid it out to your client in a way that they're able to understand. And I think the kind of meshing and the mingling of both the super academic set of requirements, but also making it personable, is what makes it really great.
I really agree with what all the other panelists have said. And there's little more I can add. In terms of what it entails, just picking up from what Emmeline just said, I also really like the interplay between the contract law, because at the heart of it, an employment contract is a contract that's analysed on contractual principles, as in other areas of life. But on top of that is overlaid a system of statutory protections, and the way those interact can be endlessly fascinating. A good example is the recent case in the Supreme Court, the Uber case, which some of you might have read about. It's just this fantastic, elegant judgment drawing together lots of different strands, where you have lots of clever lawyers on behalf of companies drawing up ever more intricate contracts to make sure that gig economy workers don't have worker status. And yet the Supreme Court says, look, these are statutory protections that are designed to protect people in these types of situations. How do we make this work? And I just love that academic challenge, but also the difference it makes in people's lives. In terms of a challenge I'd pick out, I often have clients whose concerns and goals and aims go beyond what can be achieved through litigation. And often you feel like a counsellor and a life coach rolled up into one with a lawyer. And that can be frustrating because sometimes you just can't really help, or you can only get them so far, which is why I really love mediation as well as litigation, because sometimes you can be much more creative through a mediation process than you can through litigation. Thanks.
Thank you for your insight, Rachel. John?
Well, yeah, I think I've got two things to add, because other than those two things, all been said. The first is, and who are these academic lawyers, or who are these lawyers? They're you in 5 years' time. They really are. You know, both of the lawyers from Cloisters that were in the Supreme Court, I know really well. Both of would regard as friends, and indeed, so that's the first point. The second point is, it's endlessly creative if you want it to be so. You know, it's not as though employment law had it done and dusted and there's nothing more to be said. I mean, look at what I've achieved in, well, starting out, the famous case is called Rackham, and 2 cases, and now it's in Harvey, and before there was nothing. So I profess an interest in discrimination law, and in particular rights of the disabled individual. But I've shown that with that in mind, you can change the law. And that's the most exciting thing for me, or one of the most exciting things for me, is to take these people that I know, and magically they're transformed into case names, and what failed to throw my pigeonhole as another brief turns out to be the case of the moment over XYZ. You know, it can be done, and all of the employment lawyers that you've heard from in the panel, they all do that. And wow, amazing.
Thank you, John. So all of you emphasize that employment law is very dynamic, that the case law, the law is changing all the time, that you might contribute to the changing landscape of the law, and that you help lives of ordinary people. So I would like to ask, what was the most rewarding case, perhaps, or what is the most rewarding part of your job? And to juxtapose it with the most challenging case that you've ever done in your entire career, or at least one of them. And if we could start with Rebecca once again.
I feel that I'm getting first dibs on all these. Let's skip and I'll do this one last. Amy.
Sure.
Put on the spot there. So rewarding in general, I would say is, and this pretty much echoes what you probably gathered from a lot of our comments so far, is being a mouthpiece and being an advocate for the UK workforce. And so being able to take these issues, you know, that everyone's facing in some way or another, and dispute them and litigate them in court, and being able to be a mouthpiece and put those arguments forward. And you know, there's the gravitas and pro side of that, in that, you know, you're fun to be at a dinner table discussion, for example, because you're able to discuss all these issues and issues that, you know, your friends might face at work, and be able to discuss with them and tell them their rights. So I just think that that's really rewarding, knowing about that, being on top of all of that, and being able to advocate and make people aware of their rights. There is a somewhat negative side to that, in that you become everybody's go-to in terms of all your friends wanting free legal advice about what the employers may or may not have done right or wrongly. But I'd say that in general is the most rewarding part, and being able to see the gratitude of clients once you have done a good job and a good case, and done that advocacy for them. In terms of a particular challenging, well, a particular rewarding case, I would say is I recently did a case which was regarding positive action under Section 158 of the Equality Act, and regarding a claim had been brought against my client regarding a scheme that they put into place, and it was a direct discrimination claim brought against them, and they were saying, no, we're seeking to use positive action in this case. And I won't go too much into the details of it, but getting a good judgment for them in that case, and allowing them to be able to continue with the scheme, which in my view was they were doing great work in terms of improving equality in the workplace, was really good. And I'll actually perhaps save that point for further, because I think there's a further question coming up about changes to the Equality Act, and that question, that case might tie in then. So I'll pause that there. In terms of a particularly challenging case, I would say I recently also had a very challenging case, in that it was a 6-day CVP trial, multiple discrimination claim. So not only was that in my junior career the longest trial I've done, with it being 6 days, it was also the difficulties of dealing with it over CVP. And also added to that was that my client didn't have the best prospects of success, and sometimes you have to put forward a case to argue, and of course you have to put your personal beliefs aside and still argue that case. And I personally found that case particularly challenging, because my personal views may not have entirely agreed with what was being said, and furthermore my legal views and my opinion was that, well, this might not be a great case to argue. Yeah, I don't necessarily think you have the best prospects of success on the instructions you're wanting me to argue. And there's really there the challenge of putting forward, as you're instructed to, the case that you're instructed to put forward, and the case you're instructed to make. And of course you have to cross-examine witnesses in that regard, and put that case to them, but still being able to maintain respect from the judge, and being able to not look like you're arguing, taking bad points, if you like, or you know, arguing a completely hopeless case and wasting tribunal time in that regard. And so that was particularly challenging for me, being able to find that right balance of putting forward my best case in light of the duty to my client, and being open and honest with them as to the prospects that they had, and also being able to balance that with the tribunal's respect for me as an advocate in terms of the points I was putting across. So that all mixed up into one was a particularly challenging case for me. I think that answers.
Thank you very much, Amy. Who would like to volunteer then? unless we can follow the same pattern. So Sarah, if you'd like to be the next person to speak, that's perfectly fine.
Of course. Yeah, I mean, I agree. It's the human side of it which is the most rewarding. When you've had a really good result, and that's for either employees or employers, it's often more than just about money, because as we've said, we're dealing with people's livelihoods, and people's livelihoods are a massive part of their life. So if you win a claim for an employee, and they've been vindicated, it's much more than in many areas of law where, you know, if a contractual dispute about a house conservatory or something like that. And I think my most rewarding case is also at the same time my most challenging one. And the two are somewhat connected, I suppose. But when I was very junior, I had a claim for, I was acting for the claimant, and she was bringing a claim against the Ministry of Justice for unfair dismissal. She was effectively saying that there was a vendetta to get rid of her, but she was actually employed within the Employment Tribunal service. So of course, bringing a claim in the Employment Tribunal against the Ministry of Justice about the actions of employees of the Employment Tribunal was quite daunting as somebody very junior. Unsurprisingly, the MOJ had a very senior barrister, as of course one would expect for this type of case, but my client didn't have the funds to be able to have somebody very, very senior at that time. And we had to move into different region because some of the people were known to the judges that would have been hearing the claim. So it was very challenging. The claimant was very nervous. She didn't have anyone else giving evidence on her behalf. It was somewhat of an uphill struggle. And the judge got very concerned at some of the allegations that were being made. So it was all done very carefully. But in the end, we did win. And it felt like it was extremely rewarding case, really. The client was very happy, didn't really think she would ever win, because as an individual, I suppose you think you're taking on the system, and could that ever work? So yeah, I would say that often cases which are challenging are the most rewarding.
Thank you for your insight. Emmeline, if you'd like to follow.
It's probably a reflection of my very junior level that I can think of more challenges than rewarding wins I've had. So one of the things that's already been mentioned, I think, is as a very, very junior barrister, you often find that on the other side you have somebody who is much, much more experienced. And this is the first time you see this, you think, oh my gosh, this is going to be so daunting. And it is daunting. But what I'd also say is that there is an element of it being rewarding, because you actually learn so much from who's on the other side. So it can be a great learning curve as well as a daunting one. Another challenge that I've encountered at a personal level is the extent to which sometimes you will be involved in claims where it goes so much more beyond what the claim can ever give. Even if your client goes on to win, what they really want goes so much more beyond that, and the law just can't really get them what it doesn't have the remedies available to get them all that they want. And so I think that I've found it very challenging sometimes to advise on things like settlement, where you're kind of you can give advice in relation to the law and the prospects of success, which in and of itself is very difficult, but you're also taking into account the fact that often you've got to know the client quite well, and you're aware of everything else in their life that's going on for them and why they might want to consider not actually going all the way. And so that sort of balance of all the different human interests that come into play at that stage is something that's really challenging, but really important potentially to get right, because then if you can get through to a successful settlement, then that can make a big difference and can also be a kind of victory for the client in some particular cases. So yeah, constant learning, but that in and of itself is always very rewarding as well. Thank you.
Thank you for your insight. Rachel?
So in terms of a rewarding case, I actually have two in mind, which happened a few years apart in my practice, but had some similarities. So they were both representing claimants who'd been sexually assaulted at work and then disbelieved by the employers and everyone they told at the time, which is an incredibly damaging psychological process to go through, but had found the courage to take the case, each of them, to tribunal. I really enjoyed in each case cross-examining the abuser, because I love cross-examining people who deserve it. It's something to, well, I was going to say relish, that sounds a bit mean, but it's an enjoyable part of the job. And in each case, the tribunal believed them entirely, and we got these fantastic liability findings saying they were credible witnesses who'd been through an awful time and been treated really badly and had never lied about it. And for each of them, you know, the money was nice, the outcome was nice, but that feeling of being believed by the judicial panel, who were people that they had such great respect for, who were people of authority in society, just believing what had happened to them when they went through the process of giving evidence. In each case, I've kept in touch with them afterwards. I did have a really, so just as Emily was saying, often people need things that you can't provide in tribunal. So it was a rare occasion when actually it was an incredibly healing process for my clients. That's really unusual, and I just loved being part of that in each case. In terms of a challenging case, I would say every single case I did for at least the first 2 years in practice, I was constantly terrified, thought that I was going to throw up at any minute with nerves, was often against people much more senior who knew everything and I felt were probably looking down on me, although I'm sure they were very nice about it. Sometimes with really challenging clients, and I was just sort of developing my client management skills. I remember having one case where I was representing a social worker who had taken a child by the scruff of the neck and shaken him in front of a big plate glass window behind which was the rest of the social work department, who were viewing him assaulting a child. He was then dismissed because lots of witnesses lined up to say that that's what they'd seen him do. And he brought an unfair dismissal claim, and I was representing him, and he just could not accept my advice that he didn't have good prospects of success. And he was absolutely furious with me when we lost. And I just felt terrible. So yes, experiences like that are incredibly challenging, but it does get easier the more you do it. Yes, for anyone just starting out, I'd say plow on through the first 3 years, because it gets easier after that.
Oh, thank you, Rachel. John, and then we'll go back to Rebecca.
Oh, well, my favorite case is pretty much the same as Rachel's. I had a 2-week case in Bury St Edmunds and against a major supermarket chain, and I was instructed by I don't know if you know the term, but a picker, so very low paid, who was black, and I advised him to settle, but he wouldn't. So I just said, right, we're going to fight. And everything that I asked was embedded in case law, but no one, certainly in the layman, and my opponent certainly didn't understand what you had to prove in order to prove discrimination, and the fact, yes, the facts of the case were important, but also you had to look at the questionnaire, and you had to look at codes of practice, and you had to look at the behavior of the respondent in fighting the case and whether there was something dodgy about that. And I just started doing it, and with no hope of success. And by the end, I just made some submissions, and we got the judgment, and we ended up clearing £200,000, and I was amazed. But it can be done, and to achieve that, there's no feeling like it in the world. If I want to say how my toughest case, I would say, I won't tell you who the judges were, but they were Court of Appeal judges. I won't tell you what the case was, but that was a really complicated technical EU law, international law, common law interaction, and it was set down for 2 days, and 2 nights before, I remember getting an email that the judges had indicated that this was their initial view. And I knew that that was their initial view, but knew that I had, you know, maybe a morning to convince them otherwise. And then the lead judge said, Mr. Horan, our initial view is this. Do you want us to, what do you have to say to that? And I rose to my feet and said, look, I'm going to take it out. That's all. And I started my submissions, and within 3 sentences, one of the judges cut me off and said, Mr. Horan, I don't think you understand. It's our initial view. And that really shocked me. And I guess what I'm saying is there are really great men and great women out there. They're really not great, not great in the way that I can conceive of great barristers, solicitors, and judges out there. And you're going to have to face them all. And you're going to have to box clever. And sometimes it's very, very hard. But yeah, so that's my hardest case.
Thank you, John, for your insight. And back to Rebecca.
Okay, I'm just going to add, because as you will have seen, there's a great deal of consensus amongst the panelists. And under the heading of a rewarding part of being an employment lawyer, I'm going to add that aside from the day-to-day job, we do an awful lot of other things, an awful lot of unpaid things, things like talking to you guys tonight. We've got 3 professional associations. We've got the Employment Lawyers Association, we've got the Employment Law Bar Association, and my favourite, one of which I was chair, the Industrial Law Society. And we have a fantastic employment law community. And it really does make a difference in terms of when you deal with opponents, when you come across them in court, when you know them outside of that setting as well, because it helps take the sting out of the individual battle that you're on, and it encourages, I think, good behaviour and to see the bigger picture. And I really find that part of my professional life to be very rewarding. Alongside the day-to-day cases.
Thank you, Rebecca. And before we'll proceed to the question about the Equality Act, there's one additional question that I have just received prior to the session. So if any of the panelists would like to volunteer, we will be very grateful. The question is, what is the effect that this pandemic, if there is one, have on employees and workers? And what's more important, will there be a legacy of its impacts when the UK returns to some sort of normality in the near, hopefully, future?
It's enormous, absolutely enormous, the impact of the pandemic on our field of law. I mean, a year ago, we'd never really heard the term furlough. It's a very American term, but now you've got job retention schemes, which are staving off massive large-scale redundancies. We don't know what's going to happen when the job retention schemes come to an end. We're already seeing an awful lot of claims starting to come through the tribunals in relation to abuse of the furlough scheme, you know, rogue employers putting employees on furlough and then setting up another company. There'll be that kind of stuff around the edge, but we may well see massive large scale redundancies. On the other side of the coin, I think we might see some positive changes that will come out of the pandemic. Those who can work at home have been told that they have to work at home, and a huge proportion of the population are going to find that a whole lot easier when their kids go back to school. But I think that more flexible working will filter through and become a huge part of society. I don't know whether the days when the vast majority of jobs in the City of London are done by people being at their desks, or at least having a jacket on the back of their chair between 8 a.m. and 6 p.m. every day. I personally think those days are numbered. But there are massive, massive implications of this pandemic on the world of work, because it's got massive effects on us. What do you think, John?
I couldn't agree more. I'd add to that. I talk as I guess a specialism within this a specialist. I'm a discrimination lawyer. I would say that the two things I've noticed, one positive, one negative, and starting with the negative, lo and behold, discrimination happens again to the, women, Black, Asian, Chinese, LGBT community, disabled community, and others. And it may be that it's a different kind because it's wrapped up with the pandemic, but it's the same discrimination. And we have to fight very hard for the disadvantaged groups in society. But on the positive note, it's become really easy to ask tribunals and indeed county courts for reasonable adjustments, because now everyone's asking. Literally, I've since the first pandemic was the first lockdown, so it's pretty much a year, I haven't been actually in tribunal at all. I dealt with cases, both interlocutory and final hearings, but it's all from the computer screen. And that has made judges and brother and sister lawyers realize that actually there's nothing scary about it, because when the pandemic arose, every one of us had to be careful. And, you can box your way around the problem. And it's so suddenly people are interested in reasonable adjustment for disabled and other groups of people. And what a wonder that is. Really, really exciting.
Thank you, John. If any of the panelists would like to share their thoughts on this question, it would be very helpful. But if not, then we can proceed to the next question. Okay, we should therefore proceed to the next question. And just for sake of time, we have around 20 to 25 minutes. Not all of the panelists need to answer every question. So if you would like to answer one question, if you feel you have some interesting insights, then please do. The next question is, in your opinion, does the Equality Act 2010 effectively address workplace discrimination and protect employees from unfair treatment? If it is not fully satisfactory, what changes would you like to see in the legislation?
Whose question is it? What does the questioner think? Who came up with the question?
That was a common effort of the Queen Mary Bar Society.
Okay. It's interesting. I mean, the Equality Act 2010 is the consolidating piece of legislation that brought together 9 different strands of legacy legislation. And, you know, our day job is to pick over this. And depending on what case we're dealing with at the particular time, we could give you half a dozen examples of where we don't like what it says, or it could express something differently or more clearly. I mean, I think that an area at the moment which is getting quite a lot of interest, both in academia and university settings and also in workplaces, is what is sometimes perceived as a conflict of rights. So we had a series of cases where there was a perceived conflict between the rights of gay couples to go and have to share a bed in a B&B, with the rights of the Christian B&B owners to say they only want heterosexual married couples sharing the beds in their establishments. The Christians' rights opposed to the gay rights. Is that a conflict? At the moment, there's a whole series of cases that are going through the courts that are to do with some views on transsexuals and those of more gender critical feminists. And that debate is really quite poisonous in some of its terms. And that's the thing that I was thinking. You've got lots of academic communities who are non-platforming people. We don't non-platform in the world of employment law. It all gets played out, because if people have got these views in society, they will be expressed in the workplace and they will be litigated. And is the Equality Act effective to deal with that? I don't know. And then that's the beauty of having what you heard at the outset from Emmeline and Amy and Rachel about this this area of law where you've got the black letter laws, but then you've got the case law overlaying it and interpreting it so that it's a moving, living thing. So I don't know whether that answers your question, but that's my view on the Equality Act.
That certainly does. Thank you. Who would like to speak next? Rachel, would you like? Thank you. Yes.
I have a philosophical difficulty with the structure of discrimination law, which I don't know how you would fix it, or even if it's a matter for statute law, but the way it operates is it treats discrimination as a defect or something that is out of the norm, something that's gone wrong. And I don't know if that approach is the best way of addressing some of the more structural problems in society, where inequality and discrimination is very much part of the fabric of society and indeed the way our society works. So I don't know if bringing a race discrimination claim in the employment tribunal is a good way of addressing structural race discrimination in society, for example. But I don't know what the solution would be, because it's difficult to envisage of a piece of legislation that could by itself tackle that issue. In terms of gaps in the Equality Act, I really miss the third-party harassment provisions. I think so they used to protect employees where they were harassed by somebody who wasn't a fellow employee. So for example, shop workers who are harassed by customers, or carers who are harassed by people they were caring for when they went into their houses. It used to be that employers had a duty to protect them from that kind of harassment, and that's now gone. And it's very complicated and unsatisfactory to try and bring a claim to protect someone in that situation. I really wish they'd just bring the old provisions back. They worked fine as far as I was concerned.
Thank you. Yes, John?
Yeah, I think it's all right. My concern is actually the clients, because all sorts of things are justiciable in the tribunal, but all sorts of things are not justiciable and need to be addressed, like the fact that the people I see most of are they can't afford a solicitor. In large areas of the country, their law centers aren't really working. So I'm sort of the last stop for them under direct access to counsel. And what is the use of theoretical rights if you can't actually litigate them properly? It's worthwhile looking at the UN Convention on Rights of People with Disabilities, because that addresses that concern, and you have rights to all aspects of life under the UN Convention, as opposed to work, which is what the Equalities Act, among other things, is aimed at. And boy, when you realize the international perspective and the embeddedness of every single one of those rights into a framework where they have all rights, you begin to see that the English system is, to some extent, at fault.
Oh, thank you for your insight, John. Amy, you wanted to say something. Am I right?
Yes, it was just in relation. I'd parked an example of one of my cases from earlier, and it relates to this question, and it's a particular narrow point and gap, I would say, in the Equality Act, and it's in relation to Section 158, which is positive action, and there's a rare amount of cases on this section and use of this section. So it's quite an interesting one. And I think because I've seen multiple clients and the legal profession itself starting to try and use this section of the Equality Act, which I think is great in terms of trying to diversify the workforce, I think we may potentially see this gap and issue play out. And what it is that what Section 158 envisages is that it allows employers to take action, and that's action prior to the recruitment stage, to promote equality in the workforce. So it might be, for example, if they can show that, and this is a particular example that my client had, they provided engineers in the UK, and they employed engineers, and there was a lack of women in those roles. Only 2% of their workforce were female. They can therefore take action to try and promote females into those positions. So what Section 158 allows them to do is offer sort of training days or open days, certain advertisements to that protected group, so to females, which is disadvantaged, to try and overcome that advantage. But what 158 does not apply to is, and it's absolutely clear on this, is recruitment. So it's before the recruitment stage. It's 159 that applies to recruitment. And what 159 says is that you have to essentially, if you want to positively discriminate when it comes to actually applying to a job, you have to view all both candidates, the female and the male, for example, on their merits, and then you can only positively discriminate if they're of equal merit, their applications of equal merit. But the definition of recruitment in 159 encompasses an offer of employment or a contract for work. And what my client was offering a training scheme for 4 months, and it was a paid scheme. And they were arguing that they never used 159, they never went to that recruitment stage. And they were trying to say, this is positive action. We are wanting to offer these females a paid job role because not all females would be able to take on the work otherwise. And we simply wouldn't get females into the position. It needs to be paid. And we're offering them a contract of work for 4 months so that we can address this disadvantage in our workforce. Now, that's all well and good, great. But the problem with that is that they've not actually used 159. And what they did was a male applied to this female-only trainee scheme, and they rejected him straight away, saying, you're not female, you can't apply to this program. He brings a claim, direct discrimination, section 13, to the Employment Tribunal, saying, you've not even, this is an offer of employment, and you've not even considered my application. It's discriminatory. And we go to tribunal trying to say, no, it's 158, and it's a trainee scheme trying to combat this disadvantage, and it's positive action under 158. I'm there arguing this and thinking, what the scheme's great. We've got the stats to show the disadvantage. We're showing what we're doing to overcome it. But one key legal problem is that we've offered a contract of employment, so it's classified as recruitment in that regard, and therefore we've not done what 159 requires us to do. And so legally, surely the tribunal must find that we've, no matter what, we've not complied. The tribunal found in our favour and was convinced and satisfied that we had adopted the ethos of section 158 and that that's what we were trying to do. We're trying to combat this disadvantage, and because it was simply a 4-month training program, it didn't amount to a contract of work under 159. But that, in my legal understanding of what 159 sets out, if you go to look at it, isn't entirely sound in law, because 159 excludes sort of training contracts. So you know, a 12-month training contract. It excludes other contracts of work. And so I was convinced, waiting, that sorry, I've just seen, I think, notification of the chat box. I've not yet read it, but I was convinced, waiting for an appeal to take place in that regard, that well, we hadn't correctly applied, the tribunal hadn't correctly applied the law in that case regarding their findings of whether that was a contract of employment or not. So I think that is a potential gap there, because I think people are starting to use it more. There's recently been a raft of different workplace contracts put advertised online and trying to catch up with the comments, but put online to minority groups to try and these are paid positions of employment, which I think, as the Equality Act is written, aren't lawful. But you know, that tribunal agreed that it should be lawful. My client argued it should be lawful and is continuing to do these. So I think that's a particular section that needs looked at. It's a minor point, but if it's the case that employers are wanting to go that step further and offer certain fixed contracts to work to minority and protected groups, and they have the stats to show that there's a need for it, I think that section of the Equality Act needs to be amended to allow that. But then there's the argument on the flip side of, well, where does the mark stop? How do you show the difference between the employment status of sort of a fixed term? Does it stop at 4 months? Does it stop at 12 months? What makes the difference between it amounting to a position of employment and recruitment, or just a training item. But yes, I've not read. I'm not sure if all the questions are relating to what I've said, but I think it's an interesting one, and an interesting one potentially if you're doing interviews for pupillage panels or anything, and you're looking at employment law. It's an interesting point to
and I think
discuss.
that Professor Lizzie Baums of Queen Mary's did some academic research on this. She certainly interviewed me about the topic a while ago.
Right. Is that what the comments are related
but
to?
this is, beware, whatever our latest case is, we get really into the detail of it. And we get really excited about that particular thing. And then next week, there's another one. Sorry, Amy, we're chatting in the chat box about impact of pandemic. So the latest question is, can you make workers have vaccines? Can you make them have vaccine passports? Can you make them produce it on demand? And Rachel and I are replying in the same way in real time.
Thank you very much, Amy, for your insight, and thank you very much to our panelists for answering the questions in our chat box. As we still have 2 more questions from the main part, we have already touched upon COVID, therefore this is the time for Brexit. Therefore the question is, can you tell us about the changing landscape of your field in light of Brexit? And I would add from myself, how much of the law covers with the law of the European Union that you do in the UK? What is the correlation between these laws? That will be the question.
Emmeline, you're at Blackstone, aren't you? There you go. This is one for you. Can I just say, the Industrial Law Society had a lecture by a professor at Cambridge called Catherine Barnard, who is the queen of all things to do with Brexit and employment law and labour law. And she explained, or sought to explain, the whole structure of the retained laws and where the disputes go. And I sat with a towel wrapped around my head, trying to follow it, thinking, oh my goodness. So over to the member of Blackstone Chambers.
I'm going to sound like I'm really going to be ducking out of that, because my normal approach to this question, I should say firstly, it's going to be immensely complicated and it is going to throw up all these horrible, horrible questions. But I think there is also an interesting question, because could this also offer an opportunity for really interesting arguments to be made from a common law perspective in this jurisdiction, and the opportunities that there may arise for developing our law in a way that we haven't yet been able to, and maybe some of the departures that will now be more possible to us can actually be made, subject of course to the very, very complicated competition concerns that are going to arise out of the most recent set of agreements. So I think this is very much a case of watch this space, and there's horrible work that's going to have to be done about different time periods, because what will apply in the kind of transition period will then have to change subsequently as we now get into the proper post EU environment. And so basically the kind of state of the law is kind of going to be in 3 tranches almost. There's going to be how it used to be when we were full members, how it applies in the transition period, and how it will apply from the 31st of December 2020. And so effectively, as an employment lawyer, you're going to have to be dealing with almost 3 legal worlds in terms of the timings of that and when your causes of action arise. So that's the kind of like the nitty gritty kind of analysis, and each of those will have to, you have to kind of approach it in its particular way. But I think there's this kind of broader question of the extent to which and this is kind of where our sort of discipline overlaps so interestingly with kind of wider political debates in society, because we have got now a parliament who can do things that it previously couldn't. And so the kind of politicized side of all of the additional activities and interests that we all as employment lawyers have kind of got like a bit of a new emphasis and a new impetus to them. And I think that the creativity that people have mentioned on the panel is going to be at the fore in what sort of arguments we are available for us to run. And that's sort of something which is potentially an opportunity to those at the employment bar.
That's really reassuring to hear, because I'm just getting to grips with this. I've ordered a new textbook on retained EU law rights so I can do my homework. But what I feel mainly as an employment lawyer who often is on the side of trying to expand rights is that I'm missing a tool in my toolkit, that arguments that you might have made about how things should be interpreted to give effect to EU law rights may not be available in future cases, and that feels a little sad. But I think Emlyn makes some really good points about how we should be thinking more creatively about what can be done. And I think in the chat box as well, Rebecca mentioned the unison judgment, which is a really great judgment to read if you want an example of how common law rights can be used to protect people in the workplace in this country.
Thank you very much, Rachel. And I think that due to time constraints, we should move to the next question. As today, out of our participants, maybe a majority, is studying employment law or is planning to study employment law in the third year of our course. Therefore, what advice would you give students who want to pursue a career in the field of employment law? Maybe out of your own experience, that will be obviously the most valuable.
Go on, Sarah. We've been keeping you on mute for far too long.
All right. I think my advice would be that you need to actually have first-hand experience of what employment law actually is. I didn't really realise how interested I was in it until I did my own employment cases. So for those who are studying it, a really great thing to do is go and watch an employment tribunal case, see what happens. Now, at the minute, it's a little bit more difficult because most of the cases are not actually taking place in real life at the minute. Hopefully that's going to be changing in the near future. But they are still currently public hearings, so it is still possible to actually watch some hearings online. Or even better, get some experience yourself of actually dealing with employment cases. As we've mentioned, there are lots and lots of people out there who need help and who can't afford to pay for lawyers. So no doubt having the assistance of a law student would be really great for a lot of people. And it's a good way to dip your toes in the water, because the employment tribunal is really, if a judge knows that you are providing assistance and you're a law student, they will generally be really appreciative and hopefully not give you a hideous time, and they'll understand that you won't be fully qualified. And what better way than to actually find out if you like it and see how you deal with the arguments and the judges and, most importantly, the clients.
Thank you, Sarah. Would anyone else like to share their thoughts on it?
Go and volunteer for free. Or Amy, what did you do? Did you do an advice centre when you were at Queen Mary's, Amy?
Yeah, there's I think Queen Mary has its own legal advice centre, but there's also multiple legal advice centres and citizens advice bureaus in London that you can sign up to, though I'm not sure in terms of the impact of the pandemic on those at the minute. However, just on a practical point of what Sarah said about watching tribunal hearings via CVP, the easiest way, and I'd say it's actually potentially easier for you to have sight of tribunal hearings now, given they are on CVP, is if you make an account on CourtServe online. That will, and it's easy to do, you just sign up and make an account. That will give you all the listings of the cases going on in court. So if you can click on employment tribunals and then choose a tribunal, it will give you a list of what's been taking place remotely and the contact detail for the relevant tribunal. So it's usually sort of Birmingham Tribunal, Justice Gov, whatever it might, listings, whatever it might be, and send them an email and say that you're a student and you want to watch a public case, and they'll give you the details. It's that simple, and they'll give you the details to log in. The beginning of the hearing, the judge will check that you can be heard, and perhaps might check your name and check that you don't record anything. But then you can watch a hearing. So I would say definitely do that. It's probably actually easier to do that now. And it's something that you can do while we're working remotely, and you'll learn a vast amount of stuff by doing that.
Thank you, Amy. John, would you like to add your insight? Because I saw you had your hands up.
Different question, but I'll try. I absolutely think Frew is wonderful. I was a stack Hannahite when I was a bar student and pupil, but also when I came back to the bar. It was so important to me that there was a, I can remember I phoned up and asked hesitantly because my voice wasn't up to much, and I stammered, if they wanted me to represent people again, and they said yes, and I've never looked back. But also have a think about going to court with a lawyer. Ask. I'm notorious. I never go to court, even virtual court, without a note taker, and that's a reason, because I desperately want law students and bar students to be able to not only watch the case, but realize why I did what I did. And I'm sure a lot of other employment lawyers feel the same. I'm passionate about it, and I've experienced a panel which is all full of passionate people, and we all have slightly different views about what's right and what's wrong, but the one thing we have in common is our passion. And you'd be amazed as a law student or bar student what you can get away with lawyers who, when you say, can I come to see this? Can I come to see that? They say yes. So ask us. We don't bite, and you may be surprised with what you get offered.
Thank you very much, John. Would anyone else like to share their thoughts on academic side of things? Because I am aware that we are 5 minutes over time, and therefore, if any of the participants would like to add some questions in the chat box, then this is the time for it. If not, we'll be nearing end. Let's give participants 1 minute. I think that's all of the questions were answered then. Okay, so I will head over to Claudia.
I wanted to say thank you to all of our panelists. It was a really amazing panel, especially considering it's our last event. So thank you again. It was really insightful, really useful. Just a reminder that our applications are now open for committee members for next year, which is really scary to think about, but they are open. So if anyone is interested, please do sign up. It's on our Instagram in our bio. So yeah, thank you again, and thank you, Mikhail, for hosting as well. It was really great. So thank you everyone for attending.